Yes, it's only very rarely that a section itself starts as a proviso. Normally you get a proviso to a particular section. There will be a section, there will be a proviso, further proviso, provided further that will be the wording. But here is a section which itself starts as a proviso. You have a section in the Evidence Act itself starting as a proviso. Section 100.
About the section number, but there is a proviso in the section related to presumption of life and death.
107. Section 107 and 108. Section 107 says, if a person is shown to have been alive within 30 years ago, 30 years ago, if a person is shown to have been alive, then it is for the person who says that he is dead to prove. Burden is on the person who alleges that he is dead to prove that. Then 108 is a proviso to 107, which says, however, if that person is able to show that this so-called dead person is not heard of, has not been heard of for the past 7 years, by those who would have naturally heard of him, had he been alive, then the burden shifts to the opposite party, and it is for him to show that he is alive. So, section 108 is a proviso to section 107. Then there is a pre-constitutional act, another act which is very often invoked by practitioners before the motor accidents tribunals. An old act which also contains a section which starts as a proviso. Section 2 of the Fatal Accidents Act. Fatal Accidents Act 1855, old act. Section 2 also is a proviso. It also starts as a proviso. Now, section 27 is considered to be a proviso to sections 25 and 26. 25 says no confession made to a police officer shall be used against him. 26 says no confession while in the custody of a police officer shall be used against him. 27 says, see the wording, beautifully worded. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to an offence or not, confession or not, as relates distinctly to the fact thereby discovered, may be proved. I will again read it. Provided that when any fact is deposed to as discovered. What do you mean by deposed to as discovered? When any fact is deposed to as discovered in consequence of information received from a person accused of an offence. So an accused person, information should proceed from an accused person, and a fact is deposed to. By whom? What do you mean by deposition? Deposition means the testimony on oath before a court. Is it not? You call it a deposition. I depose before a court of law. I give testimony, I give evidence before a court of law as a witness. The statement of a witness before a court of law is called deposition. So when any fact, again I will read it, provided that when any fact is deposed to as discovered. So fact discovered. Fact as deposed to is discovered in consequence of information received from an accused person in the custody of the police officer, he should be in the custody of a police officer. The accused person is in the custody of a police officer and gives an information on the strength of which a fact is discovered and is deposed to. So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. So much of that information only, as distinctly to the fact thereby discovered. Fact discovered you will find repeated in the section. You find fact discovered used twice in the section. Fact discovered. Now we will go to these problems so that we will know the section better. What is the basic idea or doctrine embedded in section 27 of the Evidence Act? What is the basic idea? Confession made to a police officer, hid by section 25. Confession made while in the custody of a police officer, also hid by section 26. then what is it that is made admissible under section 27? If the confession relates or leads to a fact discovered. If the confession leads to a fact discovered, whether it is made to a police officer or not, that which relates distinctly to the fact thereby discovered is admissible. What is that? What is the doctrine behind this principle, behind this section? The doctrine is confirmation by subsequent events. Confirmation by subsequent. The statement of the accused or the information supplied by the accused turns out to be true. It is confirmed by the subsequent recovery. Subsequent recovery confirms the truth of the statement made by the accused. The disclosure statement made by the accused is subsequently discovered to be true. So, confirmation by subsequent events is the doctrine which is behind this section. The citation is AR 2002 Supreme Court 3164. Then question 2. The words fact discovered in section 27 of the Evidence Act embrace what all aspects? We have seen that expression used twice. When any fact is deposed as discovered. Again, towards the last portion of the section also, fact discovered. Fact discovered occurs twice in the section. That expression comprehends what all things? This is the question. Many high courts in India then took the view that fact discovered means the weapon discovered. Many of the high courts took the view fact discovered means the weapon discovered. They were made fun of by the Privy Council in the celebrated Pulikuri-Kottaya's case. Pulikuri-Kottaya versus Emperor, AR 1947, Privy Council 6-7. They made fun of these high courts which said that fact discovered is weapon discovered. Privy Council said weapons were discovered long ago. Weapons were discovered long ago. Fact discovered is not weapon discovered. Fact discovered takes within its ambit the weapon produced and the place where the weapon was hidden or concealed. Not only that, and the exclusive knowledge of the accused regarding that place. The exclusive knowledge of the accused regarding that place of concealment. So, the weapon produced, the place from where the weapon was produced, and the exclusive knowledge of the accused regarding that place where the weapon was hidden or concealed. These three things together become fact discovered. Now we will read the section again. Provided that when any fact is deposed to as discovered in consequence of information received from a person accused of an offence. So, in consequence of information received from an accused person, when any fact is discovered, fact discovered means object produced, place from where the object was produced, and the exclusive knowledge of the accused regarding that. These three things together should be read as fact discovered. When any fact is discovered is deposed to. I said the deposition is the testimony before court. Who is the person who deposes before court regarding this recovery? The investigating officer. Accused doesn't come to the court. He is in the dock. He will be in the dock. The investigating officer who effected the recovery deposes before court that when I arrested the accused and while in custody I interrogated him, he gave me this following information. Based on that information, I was able to recover the object. The fact discovered is the object produced. The object was produced from the place which was exclusively known to the accused and which he divulged to me, which he revealed to me when I questioned him. Until then I was unaware of the place. He alone was having knowledge about the place. So when he disclosed the place of concealment, I got information about that place, and pursuant to that statement, when I went there, the object was lying there. So object produced, place from where the object was lying, and the exclusive knowledge of the accused regarding that place of concealment. These three things together becomes fact discovered. So, and deposed, again deposed. Deposed means investigating officer is deposing before court that when I questioned the accused after his arrest, he made the following statement to me, and the following statement should be in first hand. He cannot, investigating officer cannot say, the accused told me that he has kept the weapon there. No. Regarding the statement of the accused, he has to deposit in verbatim in the exact words of the accused. The accused, words of the accused has to be, he has to mention, state the exact words of the accused. This is what we call in Latin ipsissima verba. Ipsissima verba. That is the exact words of the accused. The investigating officer, while giving deposition before court, will have to mention the very exact words of the accused. I arrested him. While in custody, I questioned him. I interrogated him regarding the weapon. Then he told me, he gave me the following statement. That's all. Then the statement should be in the exact words of the accused. Accused will have to say, that knife I have concealed at such and such place. If I am taken there, I am willing to show the place and the knife which I have concealed. There he cannot say, when I questioned the accused, he told me that he has hidden the knife somewhere, and if he is taken there, no. Until then, he has to give his own statement. Then, when he comes to the statement of the accused, it has to be ipsissima verba, in the exact words of the accused. Pulikuri Kotaya. Pulikuri Kotaya has been followed by the Supreme Court in ever so many decisions. Any number of decisions you will come across. To cite one, year 1970 Supreme Court, 1934, 3 judges. Again, year 1972 Supreme Court, 975. Any number of rulings you will come across the Pulikuri Kotaya being reiterated. It still considers to be the leading law, the gem of the recovery evidence. Question 3. Should not the disclosure statement be made in the presence of or be overheard by the witnesses to the recovery? The police investigating officer will arrest the accused and question him. Then he will disclose the place of concealment of the weapon. Then he will go to the place. Then the accused will show the place and take out the weapon. The weapon will be taken into custody by the investigating officer, who will prepare a mahzar or panchanama, and to which there will be 2 witnesses also. And while giving evidence before court, he will prove the panchanama, get it marked as exhibit, and the witnesses to the attesters to the panchanama also may be examined or may not be examined, but they will be there to the panchanama. So the question is, should not the disclosure statement be made in the presence of or be overheard by the witnesses to the recovery? Section doesn't say that there should be witnesses. They should overhear the dialogue between the investigating officer and the accused. These are all contemporaneous records prepared by the investigating officer to give credence to what he did during investigation. Only to give credence to what he did during investigation. They are contemporaneous documents prepared by the investigating officer. Mind you, if the investigating officer may be giving evidence, maybe after weeks, after months, or even after years, he may be giving evidence before the court only after years. So, humanly impossible for any person to recollect the facts of each and every case investigated by him. This may not be the only case investigated by him. He may be investigating so many cases. So, it is humanly impossible for a person to remember the exact facts of each and every case investigated by him. Therefore, he is preparing a contemporaneous mahzar, contemporaneous panchanama, so that when he is giving evidence, as you all know, under section 159 of the Evidence Act, investigating officer can refresh his memory while giving evidence. He is entitled to refresh his memory. Only person who is entitled to refresh his memory. 159. With regard to the investigation conducted by him, he can take this mahzar, panchanama, and looking into the panchanama, he can give the facts of the investigation conducted, including recovery. Therefore, this is only a contemporaneous record. Section doesn't say he should prepare a mahzar, there should be witnesses, etc. So, it is not a requirement of law. It was so held by the Supreme Court in AR 1999 Supreme Court, 1293. The state of Himachal Pradesh versus Jeet Singh. Therefore, it is not a requirement of law. Then depose to investigating officer. If in a given case investigating officer is able to recollect the facts of a particular case investigated by him, and without even preparing a record, a contemporaneous Panjanama, he is able to depose correctly about the investigation conducted by him. Enough. Section is complied with. When any fact is deposed to as discovered in consequence of information given by an accused, requirement is met. Section is complied with. So it is enough if the investigating officer is able to recollect the facts and depose before a court. A contemporaneous record is not necessary, but they prepare a Mahasar because they will have to remember it after years, after months, even decades. Some cases may take even decades because one accused may be absconding. So trial may be delayed. Therefore, that is why police are preparing these Mahasars, not a requirement of law. Next question. On the basis of an oral disclosure statement which is not reduced into writing, the police officer in a murder case recovers the gold ornaments of the deceased. No public witness is also examined by the prosecution. Can the recovery be justified under section 27? Oral disclosure statement not reduced into writing. No public witnesses also. Will it be a recovery under section 27? We have already answered that question. Section doesn't require any Mahasar, any witnesses. If the investigating officer is shrewd enough or intelligent enough to remember the facts of each and every case, and if he is able to depose correctly about the investigation conducted by him, well and good, it's enough. S.C. Bahri versus State of Bihar, AR 1994, Supreme Court, 2420. Supreme Court said it is not necessary that he should he should reduce the statement into the disclosure statement into writing. It is not necessary that there should be public witnesses to witness the recovery or to overhear the conversation, etc. It's all not necessary under the section. Police may be doing so many things for their requirement, for purpose of record. That's all. Is it not a disclosure statement made by an accused in the absence of independent witnesses inadmissible under section 27? Same answer. Same answer. Then question 6. Should there not be formal arrest of the accused for the applicability of section 27 of the Evidence Act? Formal arrest of the accused. Not required. We have already seen under section 25 and 26 that it is enough if he is in custody or even under the ken of surveillance. He is under surveillance. Even in the temporary absence of the police, he was held to be in custody. So that alone is necessary. 2010 volume 3 SEC 56. Question 7. After making a disclosure statement regarding the weapon of offence, the accused does not lead the police to the place of concealment. Instead, the police officer, on the strength of the disclosure statement, proceeds to the spot and takes out the weapon and seizes it under a Mahasar. Is it a recovery falling under section 27?
Sir, this is the statement regarding only the weapon or the place of where the weapon is held?
Accused is arrested. He is interrogated while in custody. He gives a statement regarding the whereabouts of the weapon. Accused does not lead the police party to that spot. Instead, the police officer himself or he sends some other police officer to that spot from where the weapon is recovered under a Mahasar. Question is whether it falls under section 27 because the accused did not lead the police party to that spot.
In this case, only one element is satisfied. Other things
Which are absent?
The place was not disclosed by the...
Place is disclosed.
The exclusive knowledge is not.
Exclusive knowledge is also there. Because of his exclusive knowledge and because of the absence of knowledge of the police officer that he was not able to get at the weapon. But accused disclosed the place of concealment on the basis of which accused did not lead the police party. Accused did not lead the police party to the place of concealment.
So that is not required, sir. It is a recovery falling under.
It is a recovery falling under section 27. You are absolutely right. But unfortunately, our police force have prepared a sort of routine procedure in which they will say, I arrested the accused, I questioned him, he made the following disclosure statement in first hand, and then he, on the basis of that disclosure statement, he took the police party to that spot and took out the weapon from the place of concealment, and I took the weapon into custody under a Mauser. This is the usual stock statement of the police. It is not necessary. It is not necessary. Once he discloses the place of concealment to the police officer, who was till then totally unaware of the place of concealment, and if consequent on that disclosure statement, the weapon is recovered, accused need not lead the police party to that spot, which is a wrong practice done by the police. But there can be a situation where the accused may say, when interrogated, I know the place where the weapon is kept. If I am taken there, I will show the place as well as weapon. He is not disclosing the exact place of concealment. In such a case, accused will have to lead the police party to the spot and take out the weapon, because he alone knows. He has not disclosed the place of concealment. He only says, I know the place of concealment. If I am taken there, I will show the weapon. So he will have to take the police party to the place which is known exclusively to him. In those cases, only the police party will have to be led by the accused. Otherwise, there is no necessity at all for the police party to be led by the accused. 1989 2 KLJ 534. And there is also 1972 Supreme Court, AR 1972 Supreme Court 975, and other rulings also. Then that Parliament attack case, Navjot Sandhu's case, State of NCT versus Navjot Sandhu, 2005, volume 11, SEC 600. Question 8. The accused in a theft case, while in the custody of the police, gives the following statement. I sold the gold chain and gold ear studs which I had stolen from the house of Ajit Verma of Karol Bagh, Delhi, at Zaveri Jewellery, Chandni Chowk. If I am taken there, I will show the person to whom the above ornaments were sold. Pursuant to such statement, the accused leads the police party to the above jewellery shop from where the ornaments are recovered. Is not the above confession made by the accused admissible in its entirety under section 27 of the Evidence Act in view of the subsequent recovery of the ornaments from the jewellery shop? I sold the gold chain and gold ear studs which I had stolen from the house of Ajit Verma of Karol Bagh. Which I had stolen from the house of so and so. He is admitting the guilt. He is making a confession of the offence itself, which is inadmissible under section 25. Even though section 27 contains the word, even though it amounts to a confession, it has to distinctly relate to the fact thereby discovered. That confession should distinctly relate to the fact thereby discovered. Here it does not distinctly relate, because he is confessing the guilt. Therefore, that part of the statement which contains a clear confession hit by section 25 cannot be recorded. He is inadmissible, totally inadmissible. Supposing a police officer out of his ignorance makes such a record, and during the evidence also, investigating officer makes such a statement, and a still ignorant judge record the entire statement, whole of which is not admissible, what is to be done? The inadmissible portion will have to be excluded, severed, will have to be excluded from the admissible portion, if it is severable. It can be done as was held by Supreme Court in Muhammad Inayatullah versus State of Maharashtra, AR 1976 Supreme Court 483. Therefore, the inadmissible portion can be severed from the admissible portion. Question 9. Will the discovery evidence become inadmissible merely because the police already knew where the objects were hidden? Police already knew where the objects were hidden, but they questioned the accused and he gave the place of concealment. Then the accused led the police party to the place and the weapon was recovered. Does it become inadmissible?
I think there should be a new discovery of fact.
What is the third ingredient of Pulikuri Kottaya? Exclusive knowledge of the accused regarding that place. Police officer already knows the place. So this was an eyewash, a drama enacted by the police. Section is clearly abused. Section 27 is abused by the police officer. He already knew the place. So it is not exclusive knowledge of the accused. He already knew the place, but he was making an eyewash of a recovery. So that is, it will not fall under section 27. Because in the ordinary course, the police officer during investigation, search or other process of investigation, if he stumbles upon the weapon and he knows the place of weapon, then if he enacts a recovery evidence, it is an eyewash. So it will not stand the scrutiny of a court.
Why do police tend to do this eyewash?
To gain credibility by the court. To gain credibility. I have caught the offender, correctly caught the offender. See, this is a very clinching evidence. He himself has admitted the place of concealment. On the basis of his confession, I have recovered the weapon. But this might have been elicited by the defense during the cross-examination, that he already knew the place. So the recovery evidence falls to the ground. AR 1956 Supreme Court 217, 3 judges. 217, 3 judges. Question 10. The accused in a murder case, when arrested by the police, makes the following statement. That knife is concealed beneath the tiles of the cowshed of my neighbor Anthony. If I am taken there, I can take out the same and produce before you. Does not the above statement contain the element of criminality tending to connect the accused with the crime? That knife is concealed beneath the tiles of the cowshed of my neighbor Anthony. If I am taken there, I can take out the same and produce before you. And the weapon is also produced thereafter. But does not the above statement contain the element of criminality tending to connect the accused with the crime? Is there something missing in this statement? There is one important element missing in this statement. So as to have the element of criminality connecting the accused with the crime. That is missing. Which is that? The element of criminality which connects him with the crime. Does he say that I had concealed the weapon? Does he say that? He doesn't say that I concealed the weapon. He only says the knife is there, lying there at such and such place. I know the place. If I am taken there, I will show you the weapon and the place. His source of information can be in 3 different ways. 1, he himself might have concealed the weapon. 2, he might have seen somebody concealing the weapon. Or 3, somebody might have told him that such and such weapon is lying concealed there. All these possibilities are there. Unless it is shown by the prosecution that he himself had concealed the weapon, you cannot say that there is the element of criminality connecting him with the offence. That was the very words used by the Supreme Court in Pohalya Motia Valvi versus State of Maharashtra, 1981 SEC 530. 81 SEC 530. There are other 3 judge rulings also. 1970 Supreme Court, 1934. That is authorship of concealment. The authorship of concealment is lacking in this case. Authorship of concealment. He is not the author of concealment. He is not the person who concealed the weapon. He is not, doesn't say that. So all the 3 possibilities which I mentioned to you can be there. So unless it is also shown in his statement, I concealed the weapon at such and such place. If I am taken there, I will show you the weapon. He doesn't say I concealed. So he is not the concealer. Therefore, you cannot say that there is the element of criminality connecting him with the offence. But a full bench of the Kerala High Court held that this is not a requirement of section 27. This decision of the full bench has been misunderstood by many practitioners of law, judges also. Because that is the citation is Ajayan versus State of Kerala, 2011, 1 KLT, page 8, full bench. Because there were 2 division bench rulings of the Kerala High Court which held that if the authorship of concealment is lacking in a given case, authorship of concealment is missing in a given case, it will not fall under section 27. This the full bench said is wrong. It will fall under section 27 because Pulikuri Kotaya, 3 requirements: weapon produced, place from where the weapon is produced, exclusive knowledge of the accused. All these 3 things are present. So authorship of concealment is not a requirement of section 27. So the statement of law by two division bench rulings that it will not fall under section 27 is wrong. That's what the full bench said. Unfortunately, everybody is of the opinion, it has been misunderstood to mean that if authorship, even if authorship of concealment is absent, 27 recovery evidence can be believed. No. If the authorship of concealment is absent, even if it is absent, it will fall under section 27, but while evaluating the evidence, while appreciating the evidence, court will see whether the authorship of concealment is there or not. If the authorship of concealment is not there, then court can definitely say that there is the element of criminality connecting the accused with the crime is absent in this case. Therefore, even though it may fall under section 27, I am not inclined to accept the section 27 evidence so as to connect him with the offence. The weapon might have been placed by somebody else. He might have seen somebody else placing it, or a third person might have told him weapon is lying there. He is not responsible for that. You can't convict him for that. But therefore, authorship of concealment is an element, though not a necessary ingredient of section 27. It is definitely a circumstance which may go into the mind of the court while evaluating the evidence. That was so held by a division bench, that is, full bench was explained by Ajayan's case, that is Golden Sadishan. Ajayan's case was explained by Golden Sadishan and others versus State of Kerala, 2012, 1 KHC, short notes 27, of which the Sambal self was the author. The full bench had to be explained, otherwise a lot of misconceptions about the full bench. So it had to be explained. That was explained in Golden Sadishan versus State of Kerala. Question 11. The accused in a murder case, while in police custody without making any statement to the police, takes the police to a distant place and points out the weapon of offence hidden there. Is it not a conduct falling under section 27 of the Evidence Act? Is it admissible in evidence? He does not make any statement. He simply takes the police to a place, points out the weapon, and the weapon is discovered. Does it or does it not fall under section 27?
Action can be shouldn't be over.
You are forgetting the wording of the section. Provided that, what is the wording? Any fact is deposed to as discovered in consequence of information from a person accused of an offence. Where is the information given? He does not give any information. He does not make any statement at all. He only goes to a place, particular spot, and points out the weapon. It will not fall under section 27 for want of a statement, but it will fall under section 8 of the Evidence Act as a guilty conduct. It's a guilty conduct. Year 1979 Supreme Court 1262. Again, same volume, 1979 Supreme Court, page 400. Any number of decisions to show that it is only a guilty conduct will not fall under section 27. Question 12. A, B and C are the accused persons in a murder case. All the three are arrested by the investigating officer. When A was questioned, he gave a confession statement to the officer to the effect that himself and the other two accused persons concealed the weapon at a particular spot revealed by him. Thereafter, B and C also gave similar statement. Thereafter, the weapon was recovered from the spot mentioned by them. Will this evidence fall under section 27 of the Evidence Act? B and C, have concealed the weapon at such and such place. B was questioned. B said, myself, A and C have concealed the weapon. C was questioned. Myself and A and B concealed the weapon at such and place. Then the weapon was found in the place mentioned by all the three. Question is whether it will fall under section 27.
So I think the statement of A will fall but not of B and C.
Exactly, you are absolutely right. Once A disclosed the place of concealment, it was no more a secret for the police officer. So police officer already knew that weapon is concealed there, then the further questioning of B and C was unnecessary and rather an eyewash. Therefore, the statement can be made against only that person who made the statement first in point of time. The person who made the statement first in point of time can be used against him, not others. Because Supreme Court says there is no, in the eye of law, there is no rediscovery. Once it is discovered, you can't again rediscover it. There is no further discovery. It is already discovered. Sukhwinder Singh versus State of Punjab, 1994, 5 SEC 152. Then there is another possibility, a joint discovery. That is, A, B and C are arrested. Then the investigating officer asks them, they are placed together, all placed in a row. Where have you kept the weapon? All of them as if in a chorus mention that weapon is kept there. Single voice, all the three. Given one single voice, as if in a chorus, that the weapon is kept concealed in a particular place. Weapon is found in that place. Will it or will it not fall under section 27? Kerala High Court, speaking through Justice Padmanabhan, held that it will not fall under, it cannot be used against any one of them because you cannot say who exactly gave the statement. All of them went stated in a chorus. One single voice. So, 1988, 1 KLT 247. But then, in the Parliament attack case, Supreme Court has formulated a situation where such a situation can be there. Situation has rather visualized a situation where all the three could make a statement in chorus. I don't know how. They say that such a situation is possible. Maybe it was a terrorist maybe because it was a terrorist they wanted to say so. Otherwise, very difficult. But anyway, there is a paragraph 145 to 147. Paragraphs 145 to 147, you will find this discussion by the Supreme Court. And 2005, volume 11 SEC 600, Parliament attack case. That is Navjot Sandhu's case. I think they have reiterated that position somewhere in 2014 or so. I had that citation. Right now I don't have that citation. 2014 or so, Supreme Court reiterated that. That is a possibility. One of the possibilities that all of them together saying. First of all, will all of them be questioned simultaneously? I doubt. Question 13. A weapon is recovered on the basis of statements made by the accused during the investigation of another case. Is it admissible under section 27? Indirectly we have answered this question. Nothing, no bar. The investigating officer may be investigating some other case. While so there is on a motorbike a person comes speeding in a motorcycle. He is arrested. He is asked to stop. He stopped and his vehicle checked. We found that it is stolen vehicle. During the course of interrogation, it is seen that he had stolen other properties also. His confession is taken. Recovery is effected. Not necessarily in the same case in which the officer is investigating. It is possible. Justice Thomas in 1997 10 SEC 675. Question 14. The witnesses to the recovery of a weapon consequent on the disclosure statement of the accused are not independent and respectable inhabitants of the locality as enjoined by section 104 CRPC, clause 4 of section 100. Is the evidence of recovery admissible under section 27? They are neither independent nor respectable nor inhabitants of the locality. That is the requirement of section 104. Independent, respectable inhabitants of the locality.
It doesn't matter.
Doesn't matter. Then why the law is so harsh? Why the statute law is so harsh? In one case, Justice Thomas had taken the view that it is for the police officer if he is not able to get, because we all know the constraints of the police. When there is a recovery, when a police jeep arrives, people flock in large numbers, and once the recovery is effected, police officer will say, I want 2 witnesses. Nobody will be there. The entire crowd will vanish. Then the witnesses whom the police officer will get will be such witnesses. Who who are accused in other cases, the usual police witnesses, chance witnesses. So that they will be the type of witnesses which the police will ultimately get. So how to get over that? Section 104, does it apply to a Section 27 recovery? Section 104 is a search and seizure. Section 104, clause 4 of Section 100 CRPC pertains to search. It has no application to a Section 27 recovery. Section 27 recovery is effected during the investigation of a case where there is a statement given by the accused that regarding the place of concealment of the weapon or the incriminating substance, dead body, etc. So, consequent on the statement, the investigating police officers in the company of the accused is going to the place. At that place, some people will flock there. Any chance witness can be a witness. It is not a search under Section 100. So as to insist on independent, respectable witnesses, inhabitants. 2001 1 ACC 652. 15. Consequent on the disclosure statement made by the accused to the police officer, the police party proceeds to the exact spot mentioned by the accused, but only to find that the weapon is not there. In the course of investigation, it is revealed that a small boy had obtained the weapon from that spot and had thrown it into a pond from where the weapon is recovered. Is the disclosure statement made by the accused admissible under Section 27 of the Evidence Act? Is there confirmation by subsequent event? It is founded on this doctrine. Section 27 is founded on the doctrine of confirmation by subsequent event. Is there that doctrine applied here? Has the doctrine any application here? So will it fall under Section 27? See, the statement of the accused turned out to be true. Statement of the accused regarding the place of concealment turned out to be true. There was a new act of intervention in the form of a small boy picking it up and throwing it into a pond, for which accused is not responsible.
If you were strictly by the doctrine, then
Doctrine, now you have to see the doctrine. After all, it is not the pure letter of the law. Doctrine is invented by the courts. The section doesn't say about any doctrine confirmed by subsequent events. Section only says in any fact is deposed to. Now here is a situation where the place, exact spot mentioned by the accused turned out to be true. But there was a new act of intervention, a novus actus interveniens. Novus actus interveniens was there in the form of a small boy picking it up and throwing it to a pond, for which accused is not responsible. So Kerala High Court, solitary decision of the Kerala High Court, held that it will fall under Section 27. But I had given the citation is Vasudevan Pillai and another versus State of Kerala. ILR 1968, Volume 2, Kerala 303, corresponding to 1968 Criminal Law Journal 1362. I had also given one more an earlier citation, Ravindran and others versus State 1989 to KLJ 534 by Justice Padmanabhan, where of course there it was not, the facts were not this, but his lordship has conceived of such a situation and goes one step further to say that even if the weapon is not recovered, in such a case, the place turned out to be true and the weapon was thrown into a pond, even if the weapon is not recovered, case will fall under Section 27. That is a slight overstatement of the law. Because going by Pulikuri Kottaya, object produced should be there. The object should be there. Without the object, 27, it will not fall under 27. Yes. Then question 16. The culprit husband, who is subsequently made an accused, voluntarily goes to the police station soon after committing brutal murder of his wife and tells the sub-inspector that he butchered his wife to death and reveals the place where he had concealed the chopper. The head constable is sent to the place mentioned by the person. The head constable finds the chopper at the spot mentioned by the person and recovers it under a Mauser. Is it a discovery of a fact provable under Section 27? A statement made by a person who is not made an accused, he walks into the police station, tells the police sub-inspector, the SHO, I have brutally murdered my wife. She was an infidel, doesn't worth living. I killed her, I murdered her. Her body is lying there. Or he has mentioned the place of concealment of the chopper. And it turned out to be true. Chopper was recovered. Will it fall under section 22? Three things. One, at the time when he made the statement, he is not accused of an offence. At the time he made the statement, was he in custody? And the police officer to whom he made the statement did not recover the weapon.
We know that accused is only descriptive of the status of the person.
So it can be interpreted to a point where he subsequently becomes an accused.
Yes.
That does not make a difference whether he was.
So that requirement of section 27 is satisfied.
Yes.
So it is not necessary that at the time when he made the statement, he should be an accused. It is enough if he subsequently made an accused. That requirement is met. Custody. He should be in custody. Section 21. In the custody of the police officer. Of a police officer. Discovered in consequence received from a person accused of an offence in the custody of a police officer.
After the police were giving information, he came under the surveillance of the police. So it can be considered as a custody.
He, by his own unilateral act, submits himself to custody. Police officer does not take him into custody. Does not even utter a word. Police officer does not even utter a word. You are arrested. He doesn't say. You are taken into custody. He doesn't say. This man says, I have butchered my wife. She doesn't deserve to live. He was an infidel.
So, until they confirm that the crime has happened, they don't take him into the custody.
They don't come to know. He is for the first time informing the police officer.
Until the head constable confirms that whatever he said is true, they cannot take him into custody.
Are all the requirements of section 27 met here? This was the baffling question. This was the problem which baffled a constitutional bench of the Supreme Court. I have already given this citation in connection with some other context. The Supreme Court said, a person can be a person who offers to furnish information against himself can be said to submit himself to the custody of the police officer. He is submitting himself to the custody of a police officer who is prepared to give information against himself. He is submitting himself to the custody of the police officer. So the custody part of the section is satisfied. Then he need not be an accused at that point of time. It is enough if he subsequently made an accused. Therefore, then the recovery, the head constable recovering it is not there in the Supreme Court. That was an addition by me. It is not necessary that the officer to whom the disclosure statement is made should himself recover the weapon. He can send somebody subordinate to him also to fetch the weapon. So this falls under section 27. AER 1960, Supreme Court 1125. Question 17. Is it illegal to produce and mark as an exhibit the entire confessional statement? That part of the confessional statement which falls under section 27 alone can be marked. The entire confessional statement, for example, he might have confessed, I am the person who stabbed the victim to death. Not admissible. Hit by 25. So, the entire statement is not admissible. Only the relevant portion alone is admissible. Alok Nath Datta versus State of West Bengal, 2007, volume 12, SEC 230. But then in one case, the Supreme Court said, if the marking of the entire statement has not caused any prejudice to the accused, just because the entire statement is marked, you cannot say that the entire trial is vitiated. It can be looked into. Only thing is, you will have to confine yourself to the admissible portion of the statement, not the entire statement. 2010, 9 SEC 567. Question 18. In a murder case, it is proved that the weapon was kept concealed in a bush by the side of a public road, which was accessible to all and sundry. Will the recovery of the weapon pursuant to the disclosure statement of the accused fall under section 27 of the Evidence Act? See here, a division bench of the Kerala High Court in 1963 KLT 806 had taken the view that if the recovery of the weapon has been from a public place accessible to all and sundry, it will not fall under section 27. But that view was overruled by a 3-judges bench in 1989, 1 KLT 806, Kunjan Nadar versus Radhakrishnan versus State of Kerala, presided over by Justice UL Bhatt, who was one of the greatest session judges our country had produced. That judgment says, even if it is a public place, there can be, even in a public place, there can be places of concealment, niches of concealment. Therefore, just because it is a public place, you cannot jump to the conclusion that there cannot be any place of concealment of the weapon, so as to bring it under Section 27 of the Evidence Act. This view of the Kerala High Court has found acceptance at the hands of the Supreme Court in AR 1999, Supreme Court 1293, where the Supreme Court also took the same view. With that, we pass on to question number 20. Pursuant to the disclosure statement made by the accused, the weapon of offence is recovered by the head constable of police, but the disclosure statement was made to the Circle Inspector of Police. Will the recovery fall under Section 27 of the Evidence Act? Here, the view taken by the Kerala High Court is that it is not necessary that the officer to whom the disclosure statement is made should himself effect the recovery. It is enough if some other officer is sent for the said errand. 1979 KLT 337, Nagaran versus State of Kerala. In fact, I had the advantage of using this decision in a triple murder case at Todupuzha, where the disclosure statement was made to the Circle Inspector of Police who was investigating the offence. But the recovery was effected by the Superintendent of Police from the Subhash Park, Ernakulam. It was promptly argued before me that this will not fall under Section 27 because disclosure statement was made at Todupuzha to the Circle Inspector of Police who was investigating the offence, whereas the recovery was effected by the SP of Police from Ernakulam. I was able to meet that argument by relying on 1979 KLT 337. We now pass on to question number 21. The accused in a murder case is in judicial custody for 65 days. On the 66th day, the investigating officer, with the permission of the court, questions the accused who is in sub-jail, and pursuant to the disclosure statement of the accused, the investigating officer recovered the weapon of offence from the place of concealment revealed by the accused. Is it not admissible under Section 27 of the Evidence Act? He has been in judicial custody for 65 days. 66th day, maybe another investigating agency who took over investigation. The investigating officer takes permission of the court to question the accused while in custody. Permission granted. He goes to the jail and questions the accused after touching him so that the arrest is effected as required by the Supreme Court. He is arrested by touching on his body. Then he is questioned. During that questioning, a disclosure statement is made on the basis of which a recovery is effected of the weapon. Question is whether this will fall under Section 27 or not. It is argued by the prosecutor that at the time when he is questioned or interrogated from the sub-jail, at that point of time, he is in police custody. That is the argument. Because at the time when he is interrogated from the jail, after touching his body, he is in police custody. He has been arrested and he is in police custody. Therefore, that requirement of Section 27 is met, is the argument. CBI versus Anupam J. Kulkarni, AR 1992, Supreme Court, 1768. Police custody can be given for the first 15 days of remand. Thereafter, the custody can only be judicial custody. Here is a person who is in judicial custody for 65 days. Even if the prosecutor's argument is accepted, can it be police custody? Can there be police custody given after the first 15 days? So, under no circumstances it will fall under Section 27 of the Evidence Act. But there are some investigating agencies which, after taking over investigation, doing this sort of circus. Yes, question. In paragraph 8 of the decision rendered on 25/4/1995 by the Supreme Court of India in Jakaran Singh versus State of Punjab, AR 1995, Supreme Court 2345, corresponding to 1995 Criminal Law Journal 3992, it is observed as follows. It is an extract from the Supreme Court, original Supreme Court judgment. So far as the conscious possession of the weapon exhibit MO4 is concerned, the disclosure statement exhibit P9 inspires no confidence. Firstly, because none of the two Panch witnesses Yashpal and Sukhdev Singh ASI have been examined at the trial, and secondly because the disclosure statement does not bear the signatures or the thumb impression of the appellant. Even the recovery memo of the revolver and the cartridges exhibits P9A, which is also attested by Yashpal and Sukhdev Singh ASI, does not bear either the signature or the thumb impression of the accused. The absence of signatures or the thumb impression of an accused on the disclosure statement recorded under Section 27 of the Evidence Act detracts materially from the authenticity and reliability of the disclosure statement. It was this classic observation, major observation, on the basis of this observation that the Supreme Court acquitted the accused. In the order of acquittal, this is a very important aspect which has been extracted. Now the question is, does the above statement give the true legal position, and if not, what are the errors in the above statement? You are being called upon to point out the errors in the Supreme Court judgment.
So, Supreme Court has placed reliance on the fact that there should be thumb impressions and signatures, but the text of Section 27 does not mention the same.
What does Section 162 CRPC say? 162(1). It says that it shall not contain the signature. The 161 statement shall not contain the signature. Now, Supreme Court is criticizing the statement by saying that it does not contain the signature.
That is not a requirement in itself.
That is a wrong assumption of law. Then, last portion, the disclosure statement recorded under Section 27, which is the provision of law under which the statement of an accused is recorded. Which is the provision of law under which the statement of an accused is recorded by a police officer. 161. 161 is the section under which the statement of any person acquainted with the facts and circumstances of the case is recorded. That includes an accused person also. Therefore, the statement that is disclosure statement recorded under Section 27, wrong. It is recorded under Section 161, but the relevant portion is admissible under Section 27. This aspect of the matter was missed by the Supreme Court. Then we have already seen 94 Supreme Court 2420 that there need not be any Panch witnesses. Panch witnesses need not be there. Here the Supreme Court finds fault with not examining the witnesses and not affixing their thumb impression and signature. All wrong statements. It was based on this wrong statement of law, or this mainly recording. Of course, there were other circumstances justifying the acquittal, but anyway, this portion was mainly relied on, and this Supreme Court recorded the order of acquittal. What happened was, relying on this statement, unmerited acquittals took place throughout the length and breadth of the country. Throughout the length and breadth of the country, in all states, all magistrates, session judges, high court judges, even the Supreme Court, I will show that, even the Supreme Court relied on this statement to record unmerited acquittals. Because this is wrong statement. We have demonstrated that these statements are wrong. What happened was, exactly 1 year, this judgment was rendered on 25th April 1996, exactly 1 year therefrom. Supreme Court, realizing the folly, realizing the mistake, suo motu reviewed the judgment and deleted this objectionable part from the judgment. They however confirmed the acquittal because there were other grounds, but this projected ground was illegal, wrong. Therefore, Supreme Court, suo motu, realizing the mistake, because they were conscious that this would form a precedent for the entire country to follow. Therefore, they suo motu reviewed this judgment and deleted the objectionable portion, this portion from the judgment. But unfortunately, this deleted judgment, rather the review judgment, was not reported by any law journal in the country. Original judgment was reported both in the AIR and Criminal Law Journal. Even the AIR and Criminal Law Journal, not only that, a Supreme Court, a SC, that is Supreme Court Almanac is there, scale is there, SEC is there, SEC criminal is there, then a lot of state reports are there. None of these reports reported the review judgment. With the result, notwithstanding the suo motu review by the Supreme Court, original Jakaran Singh observation was being followed in the entire country, throughout the length and breadth of the country, and the unmerited acquittals continued. The only law journal which had reported this review judgment was the Kerala Judicial Vision, which was a bi-monthly journal published by the Kerala Directorate of Training Kerala, which was subsequently renamed as the Kerala Judicial Academy, which is there at near Angamali. Kerala Judicial Academy was originally conceived by Chief Justice Malimat. He gave the name Directorate of Training, which was subsequently renamed as Judicial Academy. So it was this Directorate of Training was having a bi-monthly journal called Kerala Judicial Vision. 98 Judicial Vision 1 Kerala, page 1, published this review judgment of the Supreme Court. That is the only journal which published the review judgment of the Supreme Court. And fortunately or unfortunately, I was then the additional director in the academy. I chanced to come across this judgment. My director also was very studious district judge. One is no more, late Achyutarani. He also came across this judgment. We discussed together. We said, why, how come no law journal has reported this review judgment? Does it not have far-reaching repercussions? So we reported in the Kerala Judicial Vision. Justice Karpaga Vinayagam of Madras High Court had occasion to refer to this judgment in one of his judgments, the Kerala Judicial Vision. The citation is Nararajan versus Union Territory of Pondicherry, 2003, Criminal Law Journal 2372 Madras. His Lordship expressed anguish over the law journals not publishing the review judgment. And even the Supreme Court, subsequently even in 2003, Jakaran Singh was cited. 95 Supreme Court was cited before the Supreme Court in 2003. AR 2003 Supreme Court 2846. And Supreme Court, blissfully ignorant about the review, distinguished that judgment. Now, Jakaran Singh, the facts were different, so we are distinguishing it. Without knowing that the objectionable part of the judgment had been deleted. This is the progression of law that happened in our country. It is interesting to note that even in 2017, the original Jakaran Singh case judgment has been cited before the Supreme Court of India, which however distinguished the case. The citation is AR 2017 Supreme Court 279, Kishore Bhatke versus State of Maharashtra. Still more interesting is the fact that one law journal which had not published the original text of Jakaran Singh published the original text of Jakaran Singh long after the review judgment, or rather the original Jakaran Singh judgment was for the first time published after the review judgment. That is 1997 SEC Criminal 651. Last question. One Davis is on trial for the murder of one George. There is evidence to show that George was murdered by Davis and one Johnny. The statement of Johnny to the effect that himself and Davis murdered George has been produced. Is not the statement of Johnny admissible against Davis under section 30? Because under section 30, the confession statement of a co-accused can be relied on. Davis and Johnny together caused the murder of George. Davis is facing trial. The statement of Johnny is produced to the effect that himself and Davis had jointly murdered the said George. Now, will it not fall under section 30 of the Evidence Act? They have to be jointly tried. Johnny is not jointly tried. Then secondly, what does section 30 say? Section 30 doesn't say it is admissible in evidence. Section 30 only says, when more persons than one are being tried jointly for the same offence, and a confession made by one of such persons affecting himself and some other such person is proved, the court may take into consideration such confession as against such other person as well as against the person who makes the confession. court may take into consideration. So even in a case where two persons are jointly tried and one of them had given a confession against the other also, implicating himself and other person, court can only take into consideration, which means court can rely on that confession by a co-accused only if it is corroborated by material particulars. Court has to look for corroboration. For that there is a constitutional bench ruling decision. But AR 1953 Supreme Court 131, 5 judges. Again 1964 Supreme Court 1184, court has to insist upon corroboration. With that we come to the end of confession known to criminal law. The extent of admissibility of confession in criminal trials. So thank you for your remarkable patience.